It's Entertainment Law Update, episode 193. We're into August of 2026 already. Hard to believe. Here we go. Hello, everybody, and welcome to another episode of Entertainment Law Update. From Los Angeles, California, I'm Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamera Bennett.
And this is our show, the podcast by entertainment lawyers about entertainment law, where each month we round up some notable cases, some news, some information, keep you informed, and hopefully a little bit entertained. And we are so grateful to you for joining us for this episode. We do welcome your feedback as well, and love your suggestions and input. So please do visit entertainmentlawupdate.com. Use the little voice widget on the side of the screen if you're so inclined, or send us an email at entertainmentlawupdate@gmail.com. So, Tamera, thank you. What's new with you?
Oh gosh, dog days of summer. Not so much new. That's kind of it.
Yeah.
I guess exciting new. We went to Red Rocks this weekend.
Oh.
And saw our first concert at the Red Rocks Amphitheater, Lucas Nelson and the Tedeschi Trucks Band. Nice. So that was super cool. We had this planned, and I was looking forward to this cool, maybe wear a sweatshirt experience in Colorado. It was 100. But it was awesome. We went to Red Rocks, and then we went ahead and drove up to the Rocky Mountain National Park and at where Estes Park is, and had a great, little bit of a long weekend. So that was nice. What about you guys?
Well, just back from a delightful Alaska cruise with my extended family. It was quite a project, organizing and getting everybody onto the boat and in each port.
Right.
But had a really nice time. If you've never been to Alaska, it is definitely a different world and a worthwhile visit, I think, for folks. So really had a good time, relaxing. It's one of those vacations, you need a vacation afterwards to recover from the vacation. And that's where I am. We just literally got off the ship on Monday, and here we are. It's Thursday, and back at it, and glad to be back at it. So anyway, we have a great rundown of stories and news items and some, I would call it esoterica, I guess we could say. But we'll start right off with a breaking news story. What were you going to say?
I said us? Esoteric?
Right. Well, the breaking news is from the German courts. The case is Gema, Gema versus Suno, the AI music company. Gema, Germany's music collecting society, represents over 100,000 composers, lyricists, and publishers. Suno is a US-based generative AI music platform. Gema filed suit on January 21st of 2025, alleging that Suno had trained its AI models on Gema's repertoire and generated outputs from that training without a license. The case centered on 6 songs by a variety of artists. And Gema actually was able to demonstrate that it could prompt Suno to reproduce outputs closely matching those works in melody, harmony, and rhythm. The court also found that Suno obtained its training data through stream ripping, that is, downloading audio from the open web rather than using any licensed channel. It mainly was YouTube, apparently. Suno had conceded prior to the ruling that it had trained on Gema's works without paying any license fees, and rested its defense on the argument that training itself doesn't require a license, as we seem to have been seeing from some U.S. court rulings about this. So the issues in the German case were whether training an AI model on copyrighted works and generating outputs from that training infringes German copyright law without a license, if there was no license, and does a German court have jurisdiction over training conducted by a U.S. company? Somewhat predictably, I think, the court ruled in favor of Gema. The court granted injunctive relief, required disclosure by Suno providing information to enable calculation of damages, as well as an award of damages in an amount yet to be determined. They reasoned that the outputs infringed the reproduction right under German copyright law, and that playing those outputs in Germany constituted unlawful reproduction and public performance. And the court went further, holding that simply offering the model and using it to generate music independently infringes an unnamed right of public performance. They said that there was no training exemption, which was Suno's core defense, that the training doesn't require a license. That was rejected outright. And coupled with Suno's admission of unlicensed training and the court's finding of stream-ripped source material, the outcome kind of followed from there. The court found on the subject of memorization that side-by-side comparisons and the complexity of the matched works let the court rule out coincidence, supporting that the infringement, supporting a finding of infringement on the output side as well as the training side. And the court ruled that German court does have jurisdiction over the US-based AI training on the theory that serving outputs to EU users subjects the underlying conduct to EU law, meaning that AI companies with EU users face exposure regardless of where the model was built or trained. And that's the broadest reach part of this that we have to think about. Now, Suno, of course, said it disagrees with this ruling and that it's evaluating its options, including an appeal. This is the second consecutive win by Gemma against a major AI company. It previously, back in November of last year, prevailed against OpenAI in a related case, and that is up on appeal to the Munich Higher Regional Court. So we will be seeing more about this, but it's telling how the German court, at least, and seemingly the EU is approaching these things.
Well, and different outcome from what we're hearing in the U.S. Just so folks can kind of get an idea of what's analogous to GEMA. I can never be sure. GEMA is the acronym. They are in many ways analogous sister relationship to BMI, ASCAP, CSAC, Global Music Rights, the performance rights organizations within the U.S. They have reciprocal collection rights for public performance, but they also do mechanical licensing. Many of these organizations outside of the U.S. do both. So that is why I think they're getting a little bit, I mean, it's interesting to me that obviously they're making arguments related to when it's a public performance, but also a mechanical reproduction. So that's how they have standing versus in the U.S. most of the time we're seeing these causes of actions, the plaintiffs being the record labels and the music publishers, not so much the licensing body for the public performance rights. I'm not sure that we've seen a suit brought by ASCAP or BMI or CSAC against any of the AI companies. It's always been on that side, the music publishers who have been bringing those actions.
Although it's interesting, this ruling does sort of talk about the performance right. So it theoretically could be the roadmap for some similar cases from
cases here.
I've been interested in watching how the European, the EU in particular, has been approaching AI and new technology and disclosure and things like that, and sort of making these sweeping regulations that will, of course, impact U.S.-based companies and individuals as well. And this is another example of that. I'm not going to call it overreach, but certainly that extensive reach. And it's something I think we need to be thinking about and maybe trying to conform with a little bit and or push back. We'll see. In fact, we have a case discussion later on about some EU ruling that is having an impact on trade relations, or could have an impact on trade relations. Right. We'll be coming back to that in a few minutes. But first, did you see this interesting study about who it is that's registering copyrights and some of the data that came out of that?
I did. I actually think I may have, I tagged it into our potential rundown. I'm not sure if other folks did too. So anyway, it's a study released by the U.S. Copyright Office and the chief economist, because we're going to talk about dollars and cents, and it's titled "The Characteristics of Authors Reflected in Copyright Registrations." So instead of focusing on copyright law, the underlying body of law, it's a study economically about who is actually filing copyright applications within the US with the US Copyright Office. The researchers analyzed millions of registrations. And this is interesting. I'm not sure. I guess they analyzed, I don't know if they analyzed registrations or applications. Our notes say registrations. So they would have been issued registrations filed between 2011 and 2024. So they got a broad window of time. They then compared that information with publicly available demographic and economic data from communities across the US to see what kind of patterns were coming up. And they did find patterns. And I don't know if the pattern surprised you or not, Gordon, but that copyright registrations tend to be more common in communities with higher levels of education, higher household incomes, older populations, larger concentrations of people working in information and entertainment industries. That part doesn't surprise me. Right, because that just makes sense. Urban areas have higher copyright registration rates than suburban or rural. And the patterns aren't the same for every type of creative work. Different categories of work show different demographic and economic characteristics, different profiles on those. I also thought it was interesting from my notes and it's a short study, it's just a few pages to go read. I think it's an interesting read, is that they did not organize the research based on how we file copyright applications. So it wasn't organized by a literary work or textual work or a work of performing arts or a dramatic work. They actually organized them, and this makes sense because it's a library, through a system called the Mark 21 bibliographic categories. So it kind of lumped some things together that I was like, I don't understand, but it does make sense. I mean, they were looking at machine readable works. Well, that's going to be our software category. Video rights or music rights are including both sound recordings and songs. So if you look at it, as I was trying to fit it all together into categories of how we file applications, that's not exactly how it was organized. I did think, as they looked at these various factors of income, geographic area, different things for machine readable, which again, I believe would encompass software. I'm not sure what else it's going to encompass, AI. It was really based upon income was the number one factor. The people who have the highest income were the ones filing these applications.
That was my takeaway sort of across the board, but specifically in the higher technology ends of things. But it really does sort of bring up this question of the disparity of how much justice can you afford, in a sense, and because access to the justice system when it comes to copyright law in particular depends on registration. That it's not a huge bar, a $65 registration or something like that. But for content creators, independent artists, and authors who are creating new stuff every week, that adds up really quickly. And if it means not, it may be the difference between being able to have full protection for your work and not. So I don't know what my opinion on that is exactly, but it's something we should be looking at and asking questions about, I think.
Yeah. I think there's helpful information there. It would be, if somebody really wanted to dig into it, I guess you could request underlying documentation for it. But again, it's a short study. We've got a link. The summary is short from the U.S. Copyright Office, and I think it's worth taking a look at.
Absolutely. Absolutely. Well, our next case that we want to talk about involves what's called the Bubble Lamp, a dispute about about the rights to make and distribute this bubble lamp. This actually comes from the designer of the Bubble Lamp collection. This is in the 1940s. George Nelson designed this collection and made a deal with Herman Miller. That's the famous furniture and design firm. Herman Miller manufactured and sold these under a series of royalty agreements. Well, George Nelson passed away, and his widow, Jacqueline, succeeded to his interests. And in 2006, she entered into a new royalty agreement with Herman Miller. That agreement was not structured as a traditional license. Instead, it defined the licensed products as products owned by Herman Miller that incorporated George Nelson designs, and it expressly provided that Herman Miller would hold exclusive right, title, and interest in the covered intellectual property, and stated that royalty payments were made in exchange for an assignment of intellectual property rights, including the copyrights and the design rights. Well, in 2015, I guess their son, Georges, who goes by Miko Nelson, executed an addendum extending the agreement to include the bubble lamp line. That addendum likewise granted Herman Miller the exclusive right to manufacture, use, and sell bubble lamps worldwide, and conditioned its effectiveness on Herman Miller acquiring the necessary intellectual property rights. So some contemporary communications from the family attorney confirmed this understanding, described the arrangement as a mechanism to compensate the family for rights that were already owned by Herman Miller, and acknowledged that the bubble lamps would extend those ownership-based rights. So years later, the Nelson heirs alleged that the successor company, MillerKnoll, had fraudulently acquired ownership of the bubble lamp trademarks and related intellectual property. They asserted claims of federal trademark infringement under the Lanham Act, state law, Michigan trademark infringement, fraud, civil conspiracy, unjust enrichment, cancellation of federal trademark registrations, and all of it rest on the contention that their ownership of that MillerKnoll's ownership of the bubble lamp intellectual property was unlawful. Well, MillerKnoll argued that the royalty agreement from 2016 and that 2015 addendum expressly granted ownership and licensing rights to the bubble lamp intellectual property, and asserted that the plaintiffs ratified those agreements by knowingly accepting royalty payments for years after learning of MillerKnoll's ownership position, and that plaintiffs therefore lacked the clear and convincing evidence necessary to establish fraud on the USPTO. So originally, this is in the District of New York, transferred to the Western District of Michigan under a forum selection clause from the contract. And after discovery, the court granted summary judgment in favor of MillerKnoll on all of the remaining claims, finding that the contracts unambiguously authorized MillerKnoll's ownership, that plaintiffs had ratified those agreements, and that no evidence supported cancellation of the trademark registrations. So it goes up to the Sixth Circuit, and they addressed four main issues. First, whether the royalty agreement and the addendum authorized MillerKnoll's ownership of the bubble lamp intellectual property, whether the trademark infringement claims could survive in light of those agreements, whether the plaintiffs ratified the agreements by accepting royalty payments even after learning of MillerKnoll's claims of ownership, and whether plaintiffs presented sufficient evidence to justify cancellation of the trademark registration based upon fraud. And the court analyzed this and determined that the contracts were what controlled this dispute. They held that that 2006 royalty agreement and 2015 addendum unambiguously granted ownership and exclusive rights to MillerKnoll. They pointed to repeated use of language about ownership rather than licensing language in those documents, and explained that the provisions could not be reconciled with plaintiff's theory of a mere license. So the contract text demonstrated that the parties intended a transfer of ownership rights. They also relied on the 2015 addendum, which extended those same rights to the bubble lamp line and granted Miller the exclusive worldwide right to manufacture, use, and sell the products. So that really looks like ownership. And they noted contemporaneous statements from the attorneys and so on. So unambiguous agreements, the contract interpretation resolved the dispute as a matter of law. That defeated the trademark claims that, having determined that they granted ownership and exclusive rights, the Sixth Circuit said plaintiffs couldn't establish unauthorized use that was required for either the federal or the state trademark claims, and especially pointing out to that sole and exclusive right to manufacture, use, and sell language. They found that the plaintiffs had indeed ratified the agreements, that even if they once possessed a viable fraud claim by accepting those royalty payments over the years, even after learning that Herman Miller claimed ownership, they ratified the agreements.
That part, it's a little I think that's one of our practice pointers to pull out of this
Yeah.
is as soon as there becomes some concern as to a dispute of ownership, it sounds like to me you got to stop taking the money.
Mm-hmm. Yeah. I mean, do you have to stop taking it, or do you have to, deposit it in some kind of a trust until the
Well,
issues are
right. Yeah, I
resolved?
don't know.
Or,
I think there's something has to be there. It sounds like from this case in
Yeah.
the Sixth Circuit, which also includes Tennessee.
Mm-hmm.
So you'd think there would be a lot of music related things coming out of that too. Is that
Yeah.
you've got to take some affirmative action related to those royalties,
Yeah.
or you're ratifying this dispute of ownership.
Or at least say something. Hey, we disagree with your interpretation, and do something
Right.
about it. And then, in most cases, I would imagine the party that's paying those royalties is going to say, "Well, till we resolve this, we're going to suspend those payments."
Yeah.
But yeah, it seems. Yeah, it's incumbent on the if you think you own something and someone else is claiming ownership, stop taking their money. Makes sense. And then the Sixth Circuit also found that there was not enough evidence, or really any evidence, to support the idea that there was fraud on the USPTO. Conclusory assertions of falsity are not sufficient to show a genuine issue of fact necessary for denial of that summary judgment. So the Sixth Circuit affirmed the judgment of the district court. MillerKnoll retains ownership and use of the bubble lamp intellectual property, and the Nelson's family claims all were dismissed. So, I guess that is the practice pointer. Is if there's a dispute of ownership, you got to actually dispute the ownership and take a stand about this kind of thing. So. Well, next up is that other one we alluded to a little earlier. On July 8th, a broad coalition, actually a very broad coalition of performers and musicians and independent labels, collection societies, unions, songwriting groups, managers, and even the Recording Academy sent a letter to the U.S. Trade Representative, Jameson Greer, warning that the European Commission is weighing a shift away from the historical national treatment and in favor of a material reciprocity in neighboring rights royalties. Now, the U.S. is one of the only developed nations in the world without a terrestrial radio performance right for sound recordings. So we got it covered for compositions, but the recordings, there's no royalty paid by the radio stations. Under national treatment, that hasn't made a difference because American performers would still get paid when their tracks aired on European radio, for example. Same terms as the European artists would receive royalties. Under this new approach, the material reciprocity rule, Europe could turn around and say, well, since the U.S. doesn't pay our artists for radio play, we won't pay American artists either. And the coalition says that this could lead to a difference of roughly $300 million a year in royalties. The trigger is a decision from 2020. The Court of Justice of the European Union made a decision in something called RAP, R-A-A-P, confirming that American performers' right to equitable remuneration in the EU exists. The independent European labels has pushed back on that result ever since, and so now the EU Commission might actually act on it. What's ironic is that the American Music Fairness Act was framed as fixing the unfairness to U.S. artists here at home. Now, that same loophole is being weaponized abroad, is what the note says, to cut U.S. artists out of those foreign royalties. So this coalition is arguing that passing the American Music Fairness Act is really the cleanest fix. So the story flips.
And that's been that's been the argument for decades.
Yeah.
As long as I've been involved with the Recording Academy, the Academy has been presenting, this is the organization that puts on the Grammy Awards, has been supporting this American Music Fairness Act and arguing, look how much money is going to stop coming into the U.S. And it's the fact that the U.S. is in great company with China, North Korea, and Iran as not having this performance right.
Yeah.
So,
Well, so now it's like, well, here's all this foreign income that has been flowing.
that looks like it's going to stop. Come on, Congress, look at this.
Yeah. So I asked the question of, why isn't this a violation of the international treaties, the Berne Convention or something like that? And the fact is the Berne Convention really doesn't address the sound recording side of it, these neighboring rights issues. Performers, record producers, and broadcasters aren't authors under the definitions of the Berne Convention. They're covered by a separate treaty, the Rome Convention, and later the WPPT, which I've forgotten what that stands for. But those laws essentially permit reservations of this broadcasting right. And so material reciprocity isn't a loophole, it's a feature of these neighboring rights treaties, and it's always been available. So now it's just being applied, or maybe applied in a new way. So that's procedural. There are some constraints that slow this down. The decision that the European Union seems to be looking at held that any reciprocity limitation has to be codified through legislation. It can't just be applied the way some of the states would like to. So it's a ways off, but it's something to be thinking about. So I guess the message is, if you represent folks in the recording artists, the session musicians, the independent labels who collect these neighboring rights revenues through sound exchange or foreign collecting societies, it's time to pay attention to this. This is not just noise. It's pre-legislative. There's no EU law yet. So this is the time for advocacy and positioning before the rules get solidified. So get into it and contact your legislators and the trade reps and make your voice heard, I guess.
Yeah. So. And I put into the show notes the link for the Recording Academy's status on this. And also, it's been a long time since I've looked into this, so I don't know if it's still a possibility. I believe if a certain amount is recorded, it used to be people would go record in London, but they're not part of the EU, but still this reciprocity applies to them too. Depending on where you record and release, you may be able to collect more royalties as a U.S. artist if you're recording and releasing outside the U.S. But I don't remember the specifics on how to make all that work. But that might be something to look into, depending on an artist's capability to do things like that.
Okay. Yeah. So we have the Register of Copyrights in the news again, still, I guess you could say. You may recall that back, when was it? Late last year that President Trump fired the Register of Copyrights Shira Perlmutter because he disapproved of advice she was giving in that 3-part report on AI. And she expressed some concerns and questions about the use of copyrighted materials by AI technology. Well, in June 30th, the Supreme Court denied the administration's emergency application in the case of Blanche versus Perlmutter. That's Todd Blanche, the acting U.S. Attorney General. They've denied the emergency application, leaving in place the D.C. Circuit's injunction, preserving Perlmutter's position while her legal challenge proceeds. So, special request from the administration to intervene by bringing it on the shadow docket, the emergency docket. But the Supreme Court wasn't having it in this instance and said, nope, this one can proceed in the normal course of business. So for the moment, Shira Perlmutter is still still entitled to be the Register of Copyrights, I guess you could say.
Yeah. So, yeah. And we'll keep watching it. So it was May. So it's just been a little over a year ago that I went back and looked as well, because I couldn't remember how long it had been. Again, I think that's interesting. It affects us a lot in many ways for continuity of what's happening at the Copyright Office. So, and
weighing in on things like the previous story, the EU stuff, the Register of Copyright plays a role there in helping craft U.S.
Because
policy.
they're advising Congress
Yeah.
as part of the Library of Congress.
Mhm.
So, which goes back to our other article as to why it was organized by library categories.
Yeah.
Anyway, so I don't know. Have you gone to buy any ice cream lately, Gordon?
Well, I was on a cruise. I was having ice cream every day.
Oh yeah. Did you and your kids count how many free ice creams you could have per day? That was always the thing we did.
I didn't count, but my kids certainly took advantage of the availability.
Took advantage of all that free ice cream.
Yeah.
So I've never had Van Leeuwen ice cream. I need to see if they sell them in my local grocery store. But they sell pints of dairy ice cream in monochrome pastel cardboard packages with a minimalist design and a black cursive script. They are out of Brooklyn and were founded in 2008. Then we also have Rebel Creamery LLC, which uses a near identical color scheme and script on their packaging. With some slight design differences. Rebel is a keto product, so of course they've got that information that everybody who eats keto wants to know on the front of their package. Van Leeuwen sued Rebel for trade dress infringement and related claims under both federal and New York law. And during a bench trial, so no jury, the court found that Rebel had infringed and diluted Van Leeuwen's trade dress and did that intentionally. So the question becomes, can a company protect the overall look of its packaging, even if it does not own any one particular color, font, or design element? Because Llewellyn in 2016 redesigned its packaging. And they introduced something that was a very monochromatic, pastel-colored cardboard pint and matching lids. Again, this black cursive lettering, clean, minimalist, lots of open space on the packaging. So that was 2016, and they're, selling across the U.S. in a variety of stores. Rebel launched in Utah in 2017, so not too long after the introduction of the new packaging. Again, it's a keto type of ice cream. Its pints included this pastel background, black cursive lettering, and a minimalist layout. So, not a whole lot of stuff on the package. Again, they had their dietary details. Wegmans, I've never been to a Wegmans. I've heard of Wegmans forever. I guess East Coast.
Grocery chain.
Cool. Yeah. Grocery chain. A Wegmans buyer reportedly told Rebel, hey, your package looks a lot like Van Leeuwen's, and Rebel didn't do anything to change their design. Van Leeuwen learns about it through social media, says, oh my goodness, we don't have a budget to fight this. What are we going to do? But then once Rebel expanded, Van Leeuwen did file suit. And they brought this on trade dress. And again, trade dress protects the overall appearance of a product or its packaging. You don't have to have a federal registration, which I was unable to find a federal registration for this trade dress. But what Van Leeuwen had to show was clearly defined, consistent design, distinctive. It had to be non-functional. And this use by Rebel had to be likely to cause consumer confusion. And the argument on the other side being, well, what is pastel? What is minimalist? Right. Sometimes Van Leeuwen wasn't consistent in how their packages looked. But the court said a trade dress description does not need mathematical precision. I thought that was interesting. Yeah. The plaintiff had identified a specific combination of colors, materials, lettering, layout. The fact that they may have had a special edition packaging didn't change that. And that the packaging was inherently distinctive because ice cream does not need to be sold in this particular style, even though, again, it was still a pint of ice cream, just like every other pint we've probably seen. Even though Rebel said they had not seen the packaging when they created their design, what may have worked against them was the fact that Rebel did not save variations on the theme of their product packaging design. They were only able to produce information related to the final design. So there was no way to kind of work through variation 1 to variation 10 of what they were putting together on their product packaging. They also made no changes after they had, I guess, some actual confusion or potential confusion from the Wegmans buyer. And this made it look a little bit less innocent in what they were doing. And I guess it looked really less innocent because the judge said it was intentional trade dress infringement dilution. So he had to have found that the Van Leeuwen's brand was famous if he was going to give a dilution ruling. Awarded $2.38 million in damages. That's a lot of ice cream.
Yeah.
So, I mean, I think takeaways, you can have trade dress in that product packaging. You've got to be able to distinguish it, define it, set it apart. And then you can enforce your rights in that trade dress. So I do think, if you can get a federal registration, even the better, that there is a process for that at the USPTO to file for trade dress and have that protected. But this is also telling us common law trade dress works too.
Yeah. And don't copy your competitor's look and feel, I guess is.
Yeah, and I mean, I'm thinking, how many different ways can you package ice cream? I suspect I'm just kind of making Rebel's arguments for them.
Yeah.
Oh, so interesting. I said it had to have been famous to get that dilution factor, but it looks like they took the dilution under New York common law or New York trade dress law. Inherently distinctive, blurring or tarnishment. They look at the Polaroid factors of analysis. So it was not under the Lanham Act trade dress where they were looking at that.
Yeah.
So, yeah, don't copy your competitor and come up with something distinctive and different.
Yeah. Well, and in this case, it sounds like the Van Leeuwen design was distinctive in that it was, I don't want to say generic, but sort of almost generic style. It was very plain design.
And that's, I mean, I went and they had pictures in the pleadings and it was just a very minimal.
Yeah.
I mean, there was, I'm thinking of what we're in Texas. I'm thinking of what a Bluebell ice cream looks like. There's a lot on the package.
And if you're selling a product that is clean, it's just sugar cream and cold, it makes sense to be very simple in your design of your packaging. And so that, I guess in this case did become distinctive for Van Leeuwen, and Rebel decided to capitalize on that same idea and to their detriment.
Yeah. So, interestingly enough, Van Leeuwen did have a handful of trademark registrations, just no trade dress registrations.
Interesting. Well, here we have a sort of interesting story. Some of our listeners may remember the name Ethan Klein. The case back in 2017 was Hosseinzadeh versus Klein. In that case, Ethan Klein and his wife Hila Klein were sued by Matt Hosseinzadeh, Matt Hoss is how he goes, for copyright infringement when they posted a commentary video mocking his YouTube video showing parkour content. The district judge in that case had ruled in favor of the Kleins, declaring that their video was fair use as a matter of law. It was a reaction video, the kind of thing where they show themselves in a small window, or they cut away to themselves responding and reacting to the material that they're commenting on. And the court held that was fair use as a matter of law. And that really was a critical precedent that led to the growth of this reaction video industry, you could call it, justifying all kinds of scene-by-scene commentary videos, justifying use of copyrighted clips, and really protecting that whole genre on YouTube, which has really become a thing. Well, about a decade later, late last year, Klein sued 3 Twitch streamers named Denims, Frogan, and Caseytron, alleging that they had infringed a copyright in his video, which was a video called Content. I'm sorry, his video is Content Nuke. And they basically did reaction videos of his, but they did very little of the commentary. In fact, some of the allegations were that they basically just turned on their camera, played the video, and even at times walked away or, went to do other things, smoked a cigarette, really wasn't reacting in much way anyway. Well, in July, the judge in this case, Judge Wesley Sue, ruled in favor of Denims, who was the last defendant standing in fighting these cases. She made a motion for judgment on the pleadings, and the court determined that her live reaction stream was, in fact, fair use. Noted that her critical commentary made the use transformative and did not serve as a market substitute for the original video. Klein has announced his plans to appeal the ruling to the Ninth Circuit. What's interesting and sort of ironic about it, of course, is that he was the groundbreaking case in these reaction videos, and then turned around and now he's a plaintiff and obviously comes at it from a different angle. His company is a production. It's called TED Entertainment. It's a production company that produces lots of content for YouTube. These online streamers were doing, they're all, what do they call it? They call it a content nuke. They contain the original footage along with edited montages, parody skits, and archival materials. And so they live streamed these reaction videos while playing his video, and there you have it. So the claims were.
And I think as I say, what set her apart, I guess, from the other defendants was that she paused the video to offer spontaneous reactions. Mm-hmm. She had a live chat going on with the audience, and she engaged with them. So there was more than just this sporadic commentary that was occurring. I still don't know that we have a good standard to know do we ever know what is transformative and what is not? But the court found that her live streaming was highly transformative, because for seconds at a time, she would pause and respond and critique the video, provide commentary and sharp criticism on the claims. So, the more the better, I guess, for transformation in this case.
And the court did go through the full 4-factor analysis, looking at the purpose and character of the use and finding that it was transformative in that way. That the purpose was to contest, criticize, and mock the plaintiff's message. And they find that, of course, weighs in favor of transformation. On the purpose of the nature of the original, it was also commentary. I guess that one didn't matter that much. They looked at the nature of the use as commercial versus non-commercial, and finding that whatever revenue was generated during her Twitch broadcast is not enough to really make it commercial enough to outweigh the transformative nature of things.
Got it.
The amount and substantiality of the portion taken in relation to the whole. They said that it doesn't weigh against an alleged infringer even when he copies the whole work if he takes no more than is necessary for his intended use. And to comment on the whole thing, you have to use the whole thing. So, and then the effect of the use on the potential market. This is where Klein was, I think, most concerned, because what he alleged they were doing was essentially getting people to watch that stream instead of his original video, drawing away viewers and therefore revenue from advertising and so on. But the court nevertheless held in favor of the defendants, granted the judgment on the pleadings, and case over. So we'll see if he appeals. But for now, I think reaction videos are here to stay.
Well, and I mean, that's in many ways, Twitch has tons of reaction videos, obviously gameplay videos, which falls into a similar,
right.
How transformative is this while I'm watching you play my game for which I own the copyright in the game. So I don't think we're done with it. I think there will be more. And like you said, we'll see if he actually appeals and goes forward.
Right. So Bad Bunny and a number of other artists have been in the news around the genre, will we call it, of reggaeton. And we've seen a pair of dueling summary judgment motions recently. The parties in this case are Cleveland Constantine Brown, who goes by Clevey, from Steely and Clevey Productions, also Carl Gibson, Shay Johnson. These are plaintiffs that claim copyright interests in the musical works Fish Market, Dembo, and Pounder, a dub mix, apparently. And they've sued Remus Music and Benito Antonio Martinez Ocasio, who is Bad Bunny, along with other artists and music companies who joined in these various motions. It was a consolidated copyright infringement action alleging that numerous popular songs unlawfully copied protectable musical elements originating in the Fish Market and related works, Dembo and Pounder songs. The history goes back to the late 80s when, in 89, Steely and Clevey created and released Fish Market, an instrumental reggae dance hall kind of work. Brown contributed drums and percussion. Steely contributed bass and melodic components. In 1990, Shabba Ranks released Dembo, which used the same musical backing as Fish Market but added vocals. Also in 90, Pounder Dub Mix was released as a replay version of the instrumental associated with Dembo. And so they filed 3 separate cases. In April of 21, Dembo 1, October of 21, Dembo 2, and May of 22, Dembo 3. And they consolidated these actions in July of 2022 because they involved overlapping legal and factual issues and numerous allegedly infringing works. And so the parties sought this phased approach, with the current phase being whether or not there's sufficient originality protectable under copyright law. Both sides moving for summary judgment on the originality and protectability issue. And there were also a bunch of other motions, about Dauber motions about the experts. We're not going to get into those, but the summary judgment analysis is available as well. Anyway, the court looked at the standards for originality and protectability and ultimately determined that since the analysis relies on material facts regarding identification, characterization, and protectability of elements of the songs at issue, which would rely on competing experts, the motions for summary judgment on this issue of originality and protectability were denied. So we'll come back to it at a trial, I guess. This is based on the fact that there's all these competing credible experts, Now, what's going on here, though, is the whole genre of reggaeton is sort of built on these rhythms and bass lines, right? So the consequences could be very wide-reaching.
And it's also I haven't dug deep into this, but when you see they've brought these 3 suits based on 3 different derivatives, versions. I mean, basically some Steely and Clevey created the beat.
Yeah.
They release it. Then I'm guessing they must have licensed it to Shabba Ranks, who created a derivative work by adding vocals to their beat.
Yeah.
Then we've got number 3, which did a variation on the instrumental version. I'm really curious to see how the copyright registrations read.
Yeah.
You know, what was done. I mean, that's probably why it's going to be a lot of this fall onto the experts. I mean, just from a paperwork standpoint, I would imagine the chain of title is a disaster.
Yeah. Yeah.
And then, like you said, we have this throughout this genre. I mean, how do you know it's reggaeton?
Yeah.
Because you know what
Yeah, it's sort of like, I mean, can you copyright the idea of the pattern that is jazz or swing or hip hop or, at some point. And so it's going to fall to a jury ultimately to figure out what's registration, what is protectable and what's not, and whether there's infringement. And teaching this stuff to a jury, you're going to have advanced work in the field of musicology just to be a juror in this case.
Oh my gosh. Yeah. I mean, the experts are going to have to present it in a way that can be understood. And I haven't read all this. I haven't looked at copyright registrations. So I'm just making a random, Tamera assessment.
Yeah. Well, look,
I think everybody's everybody's registration is going to get kicked out except the first one because they probably didn't do it right.
Right, the disclaiming the prior works.
The disclaimers of derivative works and what was the prior work. And so it's probably all going to hinge on whatever was filed for the 1989 work. But we'll see.
Yeah, it'll be interesting to watch. This was it was in the news because Bad Bunny was the Super Bowl guy this year. And
Bad Bunny's everywhere. So
anyway. A couple of quick little news tidbits before we wrap things up. First of all, the No Fakes Act dealing with it's the Nurture Originals, Foster Art, and Keep Entertainment Safe Act of 2026. Had a unanimous vote in the Senate Judiciary Committee and has now been passed on to the Senate floor. This would create a federal right over a person's voice and visual likeness, establish civil liability for unauthorized AI-generated digital replicas, and it'll hold folks liable for distributing those and hold platforms liable if they host replicas knowing that the person didn't consent. Does have carve-outs for the First Amendment and preempts future state laws on digital replicas, but leaves existing state law in place. And recently had a revision to include a counter notice procedure and an exemption for certain libraries, archives, and research institutions. It includes statutory damages for violations and all of that kind of stuff. It now moves to the Senate floor. Meanwhile, there's a companion bill in the House Judiciary Committee that also looks like it will be moving forward. So the No Fakes Act might be something to watch for. Yeah. And we also have the California law that started went into effect July 1st, basically saying that streaming services can't run ads that are louder than the content they accompany.
Hallelujah.
Right? Yeah. It could be troubling for compliance, but I imagine that, technology will find a way. And
if broadcast TV had the technology to find the way, surely the streaming services already know what the technology is.
Absolutely.
To find the way forward on that.
Well, yeah. So that's, I guess I don't know if there's like a private right of action or something under there, but we will certainly see. Hopefully, we'll see the impact of that taking place. I haven't noticed ads being very loud lately since July 1st, and we're a month in, so we'll see. Anyway, that about does it for our episode this month. We want to say thank you to our loyal listeners for spending your time with us. And if you do have feedback, and we welcome it, we hope that you will leave it for us by using that voice widget on our website over at entertainmentlawupdate.com. It's a red tab on the right side. Or just email us at entertainmentlawupdate@gmail.com. Now, Tamera, how can folks find you?
That's thank you, Gordon. I'm glad you're back from vacation and we got to record this month. You can find me online at harperbates.com, at Tamera Bennett for most of my socials, and also createprotect.com.
Okay, and I'm Gordon Firemark from Los Angeles, and thank you to Tamera for being with us for this, as we have been for 17 plus years. It's been a joy. My website is at firemark.com. The email address, gfiremark@firemark.com. On most social media websites, it's gfiremark. And let's say thank you to our team of volunteer contributors. John Janicek is our managing editor. Charles Thorne, Alexis Allen, who starts law school, I think, next week at Pepperdine. Congratulations on that, Alexis. And Lauren Malone. And if you are interested in becoming a part of this little family of contributors, please reach out to us, entertainmentlawupdate@gmail.com, and let us know. And that's a wrap for this episode of Entertainment Law.